Hey family, how are you doing? This is Raquel. Don't forget to subscribe, share, comment. So, as promised last week, we're going to talk about trust. And trust is nothing but a legal document where you map out how you want your affairs to be handled while you're alive, and certainly once you transition on to glory. And so, unlike the will, it takes effect right away. And it is private, which means you don't have to go to the courts. There's no probate. It is more expensive up front, unlike a will. A will may run you about maybe $500-600, but behind the back, it costs a whole lot more. Attorney fees alone will probably be $5,000 just to probate the will. Then there's the court costs, etc. With a trust, the fee up front will depending on where you are and the complexity of your estate. But for a trust, you probably look somewhere between maybe 4 or 5 thousand or something like that. And then on the back end, there's usually nothing. You may have to pay your trustee compensation, but that is up to you. It's not um, required, right? But some folks like to do it just to be fair with the trustee. Okay, so we have revocable trust and we have irrevocable trust. Revocable trust means that you can change it at any time. Sometimes they're called living trust or inter vivos trust. Then you have irrevocable trust, which means cannot be changed unless you get a signature of all the beneficiaries, right? And of course, you have on the irrevocable trust, you have different types of trust. You have marital trust, where if there's a spouse and one person transition, it continues to benefit the spouse and thereafter it goes to the children. You have special needs trust. You have some children who receive assistance from the state, from the government, and if you don't want additional support to affect the help that child receive from the government, you may want to get a trust, um, so that special so the child that has special needs can receive support as well as from the government without it affecting how much the child gets from the government. There are business trusts. So there are all different types of irrevocable trust. But now we're going to focus on the living trust, right? So the living trust is the one that you can be changed or inter vivos or revocable. And so a trust requires a trustee, and for the living trust, you are the trustee. You will be the one that's managing the trust, and you will name a successor in case you become legally, in case you become mentally incapacitated or you transition onto glory. That person will then become the successor. A trust can have co-successors where they're acting like trustee. Co-trustees where they're acting like trustee at the same time, or they could be one at a time. So, with the living trust, so you're the trustee and you're making decisions while you're alive. And with a trust, it must be funded. So, let's say you create a trust and you don't put any assets in the trust. You don't have a bank account with a trust name, or you don't put the house in the trust. Whatever is not in the trust is not trust property. So even if you pass away and you have a home that's not in the trust, it's not trust property, and then that trust will have to go through probate. So you need to be very careful that when you create a trust, you fund the trust and you include in the trust all that you want to be considered trust property, right? So with the trust, it also have a pour over will that says whatever I forgot to mention in the trust, I'm going to pour it into the trust from this pour over will. Real estate needs to be in the trust. Co-ops is not real estate, they're shares, but they also need to be in the trust. Whatever assets you have that you want to be considered trust property needs to be in the trust, or else you're going to still find yourself going through probate, which is the whole purpose of having a trust, is not to go through probate, right? Like I have some clients that, I want to have all my properties in America to be in the trust, but the ones out the country to not be in the trust. Please know that when that happens, you have to deal with that country and their probate laws and whatever the folks there have to go through for that estate to be probated. So you should really make sure everything you want to be in the trust is in the trust. Okay. So, okay, so now you have the trust. It takes effect right away. And so if you have a living trust, inter vivos trust, revocable trust, that does not protect you from creditors because you still own it. The IRS, the Internal Revenue Service, does not separate you from your living trust. If you are trying to establish a trust for tax purposes, you're looking more at irrevocable trust. And with an irrevocable trust, you don't own anything. You are giving away everything to the trust. You're not even the trustee. And that irrevocable trust will have its own EIN number, right? So I know a lot of individuals who want to get long-term planning, long-term nursing care, or Medicaid, try to establish a trust. And so, give me 1 second. My kettle is whistling. Hold on. Sorry, guys. I'm like a little bit under the weather. I think I'm coming down with something, so I just had to give me some tea. But in any event, we have some individuals who want long-term nursing care, and so they create a irrevocable trust where they just give away everything. They give away everything, so they don't have any assets, they own nothing. So when the government is calculating their worth to see if they qualify to get assistance for their long-term needs, they don't have any assets, right? So, but the government goes, well, depending on what state, they're going to check how far back you transfer, like 5 years, right? Because it doesn't, like if they check 5 years and you transfer within that time, it doesn't work, right? So I think, well, I know for each state is different, but you want to check your state to find out when that is. And please be mindful that if you should do that, you don't own any assets. You are literally giving away your assets, right? And so, well, at least I know in New York, your primary care home doesn't work against you. You are allowed to have your primary care home while you apply for long-term care, etc. But once you transition onto Glory, they have a year to come back and do whatever is necessary with that home to get back their money. So a lot of individuals will then create the trust, put the home in the trust. Once they pass away, the trust is no longer theirs. It's the home now belongs to the trust, so there's nothing to come back again. Nevertheless, but that is the beginning of trust. You have to, the great thing about it is that you can specify precisely who get what, when they get what age. You could say, oh, you know, if Raquel doesn't finish college, she can't get this, or Raquel can only get this once she gets to 30. Like, it's very, very specific, right? And the other thing about the trust is you cannot, you can leave your children out. So in New York, you do not have to leave things for your children, right? But don't forget the elective share. Don't forget your spouse. You cannot disinherit your spouse. Okay, so a trust is private. It takes effects right away. And so this is Big Enough Trust, and we're going to continue next time as we go into more details. Okay? Ciao, ciao.